She trusted her contractor for 11 years, then lost everything. A handshake and a friendship of 11 years ended in a courtroom, and a $50,000 loan was only the beginning of it. The plaintiff was a semi-retired interior designer who had spent 3 decades building a reputation for precision and taste. When she purchased a Victorian-era fixer-upper in the spring, she had a vision: restore it to its original grandeur without losing a single ornate detail. She wasn't looking for just any contractor. She called the man she trusted for over a decade. Someone who had tiled her first studio, renovated her daughter's bathroom, and attended her husband's funeral. He wasn't just a contractor. He was, she believed, a friend. The defendant had built his small contracting business from nothing. Starting with weekend side jobs out of the back of a pickup truck, he had grown into a 4-person operation with a modest but loyal client base. He was known for being affordable, personable, and, by most accounts, reliable. When the designer approached him about the Victorian project, he was flattered. He estimated the job at $127,000. They signed a contract in April. Work was set to begin in May. It began in May. It also fell apart in May. The plaintiff's case was methodical and damning. She entered into evidence 2 14 photographs taken over a 6-week period. Crooked crown molding, gaps in the hardwood flooring wide enough to lose a quarter in. A bathroom retilling job so uneven that a marble, placed in the center of the floor, rolled immediately toward the east wall. 3 windows, original Victorian glass, irreplaceable, were cracked during installation and quietly replaced with modern double-pane substitutes without her knowledge or consent. The estimated cost to repair the damage done, her expert witness, a licensed contractor from a neighboring county, assessed it at $89,400. She was suing for $112,000, the $89,400 in repair costs, plus the $50,000 loan she had extended to the defendant in February to help him cover payroll during a slow winter. Not a single payment had ever been returned. Her attorney argued that the botched renovation wasn't incompetence, it was indifference. The indifference of a man who had already taken what he needed. The defendant's attorney pushed back hard. The contractor took the stand himself, and he was calm, direct, and credible. He acknowledged the flaws in the work. He did not deny them. But he argued that on 3 separate occasions, he had flagged concerns to the plaintiff about the condition of the existing structure. That the original flooring joists were rotted in sections, that the window frames were too warped to hold the antique glass safely, and that the timeline she had demanded made certain compromises unavoidable. He had texts, 11 of them, sent over 5 weeks, warning her that the job was moving faster than the house could tolerate. As for the loan, he presented a handwritten agreement, signed by both parties, with a repayment schedule beginning in September. It wasn't due yet. He was not in default. He looked at the judge and said, simply, "I made mistakes on this job, but I didn't steal from her." Then the surprise witness took the stand. The defendant's former project manager, a woman who had quietly left the company 2 months after the Victorian project ended, testified under subpoena. She had not been called by either side. The judge had granted a motion to compel her testimony after her name appeared in internal company communications entered into evidence. What she described was not malice. It was collapse. She testified that during the months of the renovation, the defendant had been managing a family medical crisis, a spouse in long-term acute care, while simultaneously trying to hold together a business that was hemorrhaging money. She described a man who had shown up to job sites exhausted, distracted, and too proud to tell his oldest client that he was drowning. She also testified that on the day the Victorian windows cracked, she had personally recommended halting the project. The defendant had overruled her, not out of greed, she said, out of desperation to finish something, anything, that felt like solid ground. The judge ruled in favor of the plaintiff, but not entirely. She awarded $67,000. The verified repair costs, supported by expert testimony, reduced to reflect the plaintiff's shared role in accelerating a timeline over documented objections. The $50,000 loan, the court found, was not yet in default under the terms of the written agreement and therefore not recoverable at this time. The defendant was ordered to pay the $67,000 within 180 days or face a lien against his business assets. The contractor sold his truck to make the first payment. The friendship, by every account, did not survive the verdict. The designer finished the Victorian with a different contractor. The defendant's business closed 8 months later. The project manager's testimony changed the way the jury, and perhaps the audience, saw both of them. Not as a villain and a victim, but as two people who failed each other at the worst possible time. So here's the question. If you knew someone was quietly falling apart, would you have pressed forward anyway? And who bears the cost when compassion comes too late?